Before I begin to address the particulars of this that justify that conclusion, I do want to state to Mr. Eric Jenkins that I listened carefully to your testimony. I listened carefully to your statement here today. And I agree with your father that you have a lot to be proud of. You have nothing to be shameful for. Nothing. You did nothing wrong in this situation, and you did everything right. Hindsight is great, but you're not 15 anymore. You were 15, 16, 17 when these things were happening to you. And as the parent that's raised a 15, 16, 17-year-old, you know, those were not calls that you could or should have had to make back then in terms of whether to report, who to report, you know, what to do. The conclusions that you reached, that you testified to, that you trusted him, you relied on him, you thought either this is the right thing to do or you were doing something wrong, those were all normal, and I'm sure your counselors are telling you the same things. So please, as you go through this process of adjustment, counseling, therapy, and healing, remember that, first and foremost, that you did nothing wrong. And from there, everything should heal quicker. Once you truly accept that in your foundation, which you should, and I hope you eventually do, you will heal quicker. And I know it will be a long process, and that's normal also. The goals of sentencing are to rehabilitate an individual, to punish an individual, to protect society from that individual and deter others from committing similar crimes. And the goals of my sentence take all of those things into account. Some of the reasons that I believe sentencing beyond the guidelines are reasonable and proportionate and substantial and compelling include the following. This is a situation, Mr. Helfert, where you engaged in an extensive web of lies, a grooming process that went on for a very lengthy period of time with Mr. Jenkins. The types of violent offenses fall into two types of categories. One where an individual is boldly coming at you with some type of a weapon or a fist and is a clear and obvious aggressor or violent person. And those situations are almost less reprehensible than what we have here, because when you know the situation that you're confronted with, you can see it, you can see that this is a violent person, that this is a dangerous situation, you can leave, you can protect yourself, you can call for help. The much more damaging and dangerous and violent situation is what we have here, and that is when the individual, you, Mr. Helfert, are a wolf in sheep's clothing. That is, you are disguised completely from head to toe as a good person, a trusting person, a reliable person, a helpful person, and you are 360 degrees the opposite. And that is more dangerous because individuals can fall, as did these parents and Eric, into your web of lies and believe the deceit and trust. and trust you. The grooming in this situation started when the victim here was only 15, 16 years old. As I indicated earlier, he originally was in the room with another individual, but then was put into the smaller room when the one-on-one tutoring began, locked in that room in the school that was used for tutoring by Officer Brian, who was in uniform, including his gun. And the grooming, the touching, started by applying aftershave to the victim's groin area, pubic areas, and as I indicated earlier, a lot of uncomfortableness by the victim not wanting to expose himself, but the repeated, almost forceful pushing by an adult tutor, police officer to this young boy to eventually expose more of himself, to allow fondling of his private parts, use of ointment, the allowing of the ointment to be inserted into private parts. This was all a progression of very slow, methodical, manipulative, premeditated progression. Supplemented by purchases made by Mr. Helfert for the victim in order to bring him into the fold and get him to trust him. And then that was used to obtain more sexual favors in return for the financial gifts and things that were purchased for the victim. The defendant, Mr. Helfert, groomed Mr. Jenkins, the victim, who was undisputably, from his testimony, an emotionally vulnerable boy. He was groomed and manipulated into a long-term abusive relationship. The grooming appeared to be so pervasive, successful in getting what you wanted, that I would consider it close to a brainwashing, convincing the victim to continue this relationship beyond his years of a minor into his adulthood. So this pattern of grooming, the act of grooming, not something that's considered in the guidelines, something that is significant in this case, because as I stated, the manipulative, the premeditative nature of it is a basis for exceeding the guidelines. The pattern of criminal behavior. The defendant, Mr. Helfert, was convicted by a plea, and yes, a no contest plea, on October 9, 2020, of attempted accosting a minor for immoral purposes. In reading the PSI from that, because that wasn't my case, from that case, and comparing it to the testimony of this case, the grooming patterns are nearly identical. In both cases, the defendant, Mr. Helfert, used his authority status as a school resource officer, a police officer, a mentor, a father figure to these boys to gain their trust. You, Mr. Helfert, picked vulnerable boys, never girls, vulnerable boys, similarly manipulated them into feeling indebted to you with your gifts and your purchases, and continually pushed for sexual favors as a method of repayment. In the other case, the other conviction, the 2020 case, Mr. Helfert, you stated, it was in your defendant's statement of the offense, I loaned, and I'm going to use TH instead of the boy's name. I loaned TH money for such things as birthday presents for his girlfriend, Mother's Day flowers for his mother. Quote, I made statements to TH referencing the use of rectal thermometers and performing enemas. At the time I made these statements to TH, he was 15 years old. These statements were intended to be attempted solicitation on how he could repay me for the money I loaned him. These attempts at solicitation of indecent acts were inappropriate and I should have used better judgment. I admit those comments made to a 15-year-old would encourage or entice that minor to engage in an act of gross indecency or an immoral act. Therefore, I pled guilty to attempting to encourage or entice a minor for immoral purposes. I'm not sure if I was guilty or no contest, it doesn't matter, but I'm quoting you when you said guilty. The similar patterns of grooming from that statement, your own words, to this situation are strikingly clear. Additionally, we heard testimony at the trial from another victim, in addition to TH. It was submitted in the form of the reading of his preliminary exam, and the reason for that was because I took testimony from him over Zoom, and he testified to the level of his mental deterioration as a result of the abuse that he went through with Mr. Helfert, along with other underlying issues that he has. Again, Mr. Helfert picked vulnerable individuals, so not surprising that they have other issues. But the testimony that he gave in his preliminary exam, again, was clearly another situation of similar grooming, sexual contact by the defendant when the victim was a minor, and Mr. Helfert was a school resource officer, police officer. There has not been a conviction in that case. His testimony has been submitted as part of this case. It is appropriate to consider in determining the pattern of behavior by Mr. Helfert. This victim was so traumatized that he has been suicidal and said he thinks on a daily basis about killing himself. He is mentally unable to cooperate in a prosecution for the criminal acts that he testified happened to him. Again, not strong enough, not as strong as Mr. Jenkins, to go through this very difficult ordeal. But again, the pattern is strikingly similar. I believe the guidelines themselves, well, they don't take into account any of what I've just elicited. In addition, they're insufficient in that 10 points were assessed in OV 10 for both exploitation of a victim's youth, and it states, or the offender abused his or her authority status. So 10 points are assessed for either of those situations. In this case, both of those situations are present. So I believe the scoring is insufficient there under the facts of this case. 10 points is extremely low for the type of behavior that went on that's considered by OV 10, exploitation. And 2, we have both situations here, not 1. The scoring total of OV is 125. I believe that that is also insufficient under the guidelines, not the scoring of 125, but the fact that the Class C OV level 6 maxes out at 75. And here we're at 125. So there's 50 points there that really, under the guidelines, if I were to follow them, are not even considered or scored in the determination of the potential and appropriate penalty. OV 13 does score 25 points, I think, were assessed for continuing pattern of criminal behavior. And as I stated earlier in the sentencing hearing, it states the offense was part of a pattern of felonious criminal activity involving 3 or more crimes against a person, 3 or more, and 25 points. Here, there are so many more than 3 times. The victim testified that the defendant performed at least 10 lump checks his junior year, more his senior year, but if we don't even count them because of his age, there were at least the 10 which were described as a sexual touching lump check. The aftershave was all applied to his private areas, and that was done on a very regular basis, multiple times. So I think OB 13 is also insufficient. And OB 13 only deals with offenses that affected this victim. It doesn't deal with the continuing pattern of criminal behavior that looks at other victims, which I've already gone over. This conviction was for criminal sexual conduct in the 2nd degree. It's punishable by up to 15 years. The jury clearly took its time and carefully considered all of the testimony that was submitted to it, and they came up with an appropriate and unanimous verdict of guilty on these charges. They sent questions back to the court. We answered those questions. And the questions were clear that they were considering every defense, every argument, every issue that Mr. Helfert and his attorney were raising with regard to these challenges. And I thank the jury for their thoughtful, complete, and thorough consideration of the facts and applying it to the law in this case. We gave them a great deal of law, a complicated set of facts, and they definitely took their time, they took their job seriously, and it's a very difficult job that they have, and I want to commend them and thank them for what they did. I know that there were some individuals that you could just tell on their faces that they were putting their whole heart and soul into the decision. They understood the magnitude that they were judging another individual who was charged with a very serious offense, and they understood that there was a victim here that needed justice. And after the conclusion of the jury trial, I thank the attorneys, as I always do, and I want to thank them again because it's a difficult job that they both have. And Joe Public can sit back and say whatever they want and think whatever they want about what is appropriate. But really, unless you are talking to the victims, putting forth the defense, and analyzing the law, you really aren't in a position to know what is the appropriate manner of proceeding. And these two attorneys acted civilly towards each other, but zealously in their presentation of their cases. It's always difficult as a judge to have to pass sentence on an individual, particularly so when you have someone who has spent many years wearing the badge. But in this case, Mr. Helfert, that badge was woefully betrayed. I don't think I could say it any better than Eric or Ted have said it here today. But justice in this case requires that you be away from the public, that the public be protected from you, and that it be for a considerable period of time. It is the decision of this court, Mr. Helfert, that you be sentenced to the Michigan Department of Corrections for a minimum period of 9 years to a maximum of 15 years with credit for 757 days served. You must register as required by the Michigan Sex Offenders Registration Act and comply with all of those requirements. You must pay restitution. I'm going to reserve that issue, and I'm going to request some further proofs, either by way of hearing or presentation of documents to the court. But I do believe some amount of restitution is appropriate. The amount will have to be determined at a later date. You must pay a crime victim assessment fee in the amount of $130 as ordered by the court. You must pay $68 in state costs as ordered by the court. And there's a recommendation for $9,472.97 jury cost reimbursement. Was that the cost from this trial?
Yes, Your Honor.
Okay, you got verification of that from the clerk?
Yes.
All right. I will order that amount of repayment. You have the right, Mr. Helfert, to appeal this conviction and sentence. We're handing you 2 copies of those appeal rights. Sign one acknowledging receipt, the other is for your own records. If you wish to appeal, that is the form that you would fill out. You have 42 days from today's date if you want a court-appointed attorney for any appeal. Anything further in this matter, Mr. Stupak?
Oh, Your Honor.
Mr. Roth?
No, Your Honor, thank you.
All right, good luck to you, Mr. Helfert. That has been initially